All right, so today we're talking to David Anthony Smith, who is an Atlanta personal injury lawyer licensed in Georgia and Tennessee, about new changes in the law of Georgia that may make it harder for injured plaintiffs to recover. So David, what is going on in the state of Georgia? What do we need to know?
Okay. So Georgia has passed a bill that's called a tort reform bill, and these are measures that will have the effect of limiting plaintiffs' recoveries. There's really three big points here. The first is for medical expenses. Plaintiffs previously could recover what was billed. Now they're most likely going to only be able to get what was paid. The evidence of paid medical expenses was not allowed before this law. That will come into evidence, and a jury could determine that the paid amount is the reasonable and fair amount, and that'll limit recoveries. The second...
Well, let's say that real quick. Why is that important? What difference does that make?
Makes a difference because if you have a case where your medical expenses were, say, $50,000 in billed expenses, it used to be that you could present that and say, here are my bills and these are my expenses. Now, the relevant thing will be, well, what did your health plan pay for those expenses? And that's often a lot less than that because that's a negotiated rate from the bill. So you would only be able to get your paid expenses, which might, in that example, be half of that in some cases, like $25,000. So there's a big difference between what you billed expenses are and what was paid, and now the cases in Georgia are going to involve the paid expense amount.
So does the jury get to hear what the billed amount was, or how is this going to work in practice?
So the law says that the jury has to award the reasonable value of medical expenses, and that it's for the jury to decide what that is. They will see the evidence of both the billed amounts and the paid amounts. So I read the law to say that they could award the billed amounts, but that may be unlikely to happen if the jury doesn't think that that's fair to the defense. The second thing this law does is it attempts to limit non-economic damages. So non-economic damages are damages for pain and suffering from an injury, as opposed to economic, which would be the medical expenses. Importantly, Georgia does not cap non-economic damages. Some other states have a cap on what a jury can award. The jury can give as much as they want in non-economic damages, and this Georgia Supreme Court has held that that's constitutional. So this package of reforms, this bill by Governor Kemp here, is trying to limit non-economic damages in a couple of ways. The first big way is to address something that happens in trials, which is known as anchoring, which is really an attempt by the plaintiff's attorney to inform the jury about really ways of thinking about the value of life, using specific examples of non-economic damages. This bill now restricts the plaintiff's attorney from suggesting specific dollar amounts for pain and suffering, except at the close of trial. And really, this is just going to make it harder for jurors to understand the significance of injuries. So the jury could still give as much as they want in terms of non-economic damages. It's
Well,
up
let's
to
just drill down on that. This new law does not place caps on damages. Is that
it does
right?
not place caps
So
on
this
damages.
is their way to get around caps. They're going to say trial lawyers can't make these flowery comparisons to jet fighters and pro athlete compensation.
That's right.
Okay.
That's right. And the second thing is that this bill for cases that are over $150,000 allows for the defense to bifurcate the trial, which means it can split the trial into two phases, one that goes to liability and one that goes to damages. So before this, you would have a trial and the jury would decide whether the defendant was at fault. And if they found the defendant was at fault, they would award damages. And you would hear evidence as to damages and fault from the witnesses all at once. Now, this bill has made it so that there'll be a first phase of the trial that just goes to fault, and the jury won't have an idea of the plaintiff's damages or injuries. Again, there's no cap in Georgia, but this is a quote reform to try to limit damages because the defense or the insurance companies believe that jurors are biased when making a determination about fault if they know that the plaintiff was very injured. In other words, they find a way to put some blame on the insurance company or the defendant just because they feel bad for the plaintiff because of the injuries. So the thinking here is that if they don't know about the extent of the injuries, they'll find in cases where they otherwise wouldn't that the defendant wasn't at fault. The last way that this bill limits damages is in allowing, in car accident cases, evidence of whether the plaintiff was wearing his seatbelt or not. Previously, there was no evidence allowed of whether you had your seatbelt on or not. Now that comes into evidence, and if the plaintiff failed to wear their seatbelt, the defense can argue that that was negligent and that you sustained worse damages than you would have because of that failure. So this is a way for the defense to blame the plaintiff for not wearing a seatbelt and to mitigate damages if the injuries were worse because the plaintiff wasn't wearing a seatbelt.
Yeah. In Tennessee, for example, it doesn't come into evidence whether someone was wearing a seatbelt, and the insurance companies can't use it against you. But in Georgia, they will be able to do that now. So of all these changes, what do you think is going to have the biggest impact on the practice of personal injury law in the state of Georgia?
I think the biggest one is the treatment of medical expenses. Now, insurance companies, particularly in car accidents, are going to calculate and evaluate those claims based on the paid medical expense amount, which often is significantly less than the billed amount. So, and this has lots of ramifications because insurance companies sometimes value cases based on a multiple of the medical expenses. So if you had $20,000 in medical expenses, the case might be worth $60,000 as a settlement. Well, now those $20,000 of medical expenses only includes the paid amount, which might only be $5,000. So the case, by the same logic, would be worth only, say, 15. So there could be a significant drop in value of cases based on the treatment of the medical expenses. So there you have it. That's a recap of the key provisions of Georgia's new tort reform law. If you want to learn more about personal injury cases in Georgia, click below to watch our video on Atlanta trucking accidents.